Well, hello, everyone. Hello, everyone. This is Wilson Cole. I'm with Adams, Evans, Ross, president of Adams, Evans, and Ross and Backdoor Hires. I am joined by my lovely daughter and our general counsel and staff attorney, Samantha. Hey, Sam, how you doing?
I'm doing good. How are you?
Doing fine. I want to spend a few moments talking about a subject that people kind of cringe a little bit because there's so much unknown, and I want to kind of lift back the curtain so they can see what to expect on lawsuits. And this is pretty much as a general rule, it's the same path that all lawsuits follow. There's some variations by different states. There's some variations from attorney to attorney on whether you're paying an attorney by the hourly or by the contingency arrangement like we typically have with our clients when we forward out. But the lifespan of the lawsuit is pretty much going to be identical. And let me kind of set the stage, and I'll bring you in when we get into the specifics. But 83% of the time, an account that comes in for collections, Adams, Evans, and Ross is going to get it collected in-house with our collection staff or from our very competent counsel, Sam, here online. But that's the good news. Bad news is about 1 out of 5 we're not going to collect. About half of those we'll recommend for suit. And once the client says, yes, Wilson, I want to go ahead and have suit filed, what happens is we send it out to the attorney. We invoice you for court cost. The attorney, a lot of times, will have to make a demand and give notice. It varies from state to state what that demand is, but they have to put the debtor on notice. And they send out the notice and they say, hey, if you don't pay this in the next 30 days, 10 days, 15 days, whatever it is, we're going to have suit filed. So when we send it out to the attorney, it takes about a week to 10 days for that attorney to get it in, do their due diligence, make sure they don't have a conflict, load it up, send out that first letter, and then somewhere between 30 days and now, they're going to come back, we're going to reach out to them, and they're going to say, hey, Wilson, they didn't pay, let's go ahead and sue them. At that point, we would have already received your suit fees that you would have sent in, but we're a lot closer to that 30 to 45 day mark since we had that initial conversation. At that point, the debtor files suit, the paperwork goes to the courts, then goes out to the sheriff's office or marshal, and then they go out.
I'd like to add in one thing. If we have not received suit fees, suit will not be filed.
Absolutely. We cannot.
We run into, has it been filed yet? And it's like, no, we've been asking you for the past 3 months for suit fees.
Yes. And you're absolutely right. And the reason Sam mentions that, in some states and in most states, an attorney cannot pay those court costs on your behalf. So we have to have those court costs to have suit filed. And we do run into that on occasion. What typically happens—
Or it says that they'll cover costs in the contract. It's like, okay, that's paid back on the end. That's
paid back on the end. The debtor is never going to give you a check to sue them. You can ask the courts to give you that money back, and that's what happens there. So suit gets filed, it goes out to the sheriff, and in some states, it's very easy. The debtor, sheriff goes out, serves the debtor, they're served, they have 45 days to respond. Unfortunately, though, sometimes they have 30 to 45 days. Well, it's typically 30, but if they wait 45 days, they may have to reimburse court costs, or like here in Georgia, for instance, if you don't file within 30, you almost get like a 2-week grace period, but you have to pay pay court costs. And in some states, and those are the kind of the nuances, but once they are served, that clock starts running. They will file an answer and say, we don't owe it because, and then at that point, it goes into roughly 6 months worth of discovery. At the end of 6 months, they set up a court date, and it's about a 12-month process. Sam, what happens if you go out there, the sheriff goes to serve ABC debtor, Fred Smith's not coming out of his office, Fred Smith is avoiding his office, the sheriff's not able to get him served? What's some of the options? Because that is where most of the slowdown at the beginning comes.
It really depends on the state. Georgia, you can serve them by UPS. of, you know, the minute that that package lands on their front door, the clock starts ticking.
Okay. Now, is that suing them through, that would be suing them through the Secretary of State through the registered agent, or is that any officer?
That's any officer. You can mail it, put it in UPS. I mean, Georgia has some pretty liberal laws on service of process. I mean, you can drop it in the mail and then just start counting after 5 days. And the assumption is they've received it.
Georgia is the exception, though.
Yes.
And in my opinion, California is the extreme. California is a hand-to-hand state, which means a process server or a sheriff has to take that paperwork and pass it to the hands of the other. And there are literally, you know, where I've talked to a private investigator and he says, I had to chase a guy for a half a mile to give you, I mean, literally they're running down.
And it's not like you can throw it at them. It has to actually physically touch their hands.
Exactly. So in some states, where they have hand-to-hand service, but after you jump through about 10 different hurdles, you can sue them through the Secretary of State in a very similar service to what Samantha describes.
However, my favorite hand-to-hand state service of process story is kind of one of these that you hear through law school or continuing eds, where a man out in, it was a officer that they were able to serve him out in Vegas through individuals that he would visit, showgirls in Vegas.
So they had a showgirl serve him. I thought in some states, does Vegas not require you to have a private investigator or a marshal serve them? It can just
some states it's just anybody over the age of 18 that's not a party to the lawsuit.
Yeah, she may not have been a party to that lawsuit, but you kind of wonder if she was the cause of that lawsuit. The old Jimmy Buffett song, some people claim there's a woman to blame. Yeah.
But, you know, some of my favorite, you know, sit around is hearing people talk about creative ways they've served people, because again, that can be the biggest slowdown.
Exactly. I always tell our clients there's going to be when they say I want to have suit filed, there's a 30 to 45 day delay to get it out to the attorneys, have them do their due diligence, send out the demand, and then they come back and say, okay, let's go ahead and sue them. It can take anywhere from 30 days to 6 months and sometimes longer to get them served. Once they're served, it kind of gets on that conveyor system of the legal system. But if you don't have service, or if you don't do service properly, then they can use that to overturn a judgment. We have one out in Texas to where we're getting a judgment, but they have thrown up every defense that they possibly can to try to get this judgment set aside. And 90% of their different defenses have been is they weren't served properly. And so you have to be very thorough on that. Now, once you get them served, once you get them sued, now let's assume that you get a judgment. There again, each state is different. South Carolina, you can't garnish. The only thing you can do is haul them into court and the judge looks at them.
There are different types of judgments if we're talking about if they answer the lawsuit or not.
Oh, well, there's different, and that's a good point. With Samantha, what she's talking about is a judgment you can still enforce any of them, but a default judgment is when they get served, we know they were served, and they never file an answer. Sam, kind of give us an overview of what a default judgment is and the mentality of the courts on how somebody can get served, they don't file a response, and you can still get a judgment.
Well, even with default judgments, there's two different. You have each state calls it something different, but like a clerk default judgment where the clerk of courts goes, they didn't file this. It looks like you have a solid amount on your invoices of what it is. Here you go, rubber stamp, go do what you need to do to enforce it. Those can easily be, more easily be overturned if the debtor comes back and goes, wait, so sorry, meant to answer this, my cat was up in a tree or whatever excuse they spin.
Yeah.
Courts will sometimes reopen it, and a lot of times, depending on the excuse, will reopen it to give that chance of things like that. However, the courts also look at it as they didn't ignore you. they ignored the court.
Okay.
So courts they don't look favorably upon people not answering lawsuits.
Sure.
You also have a judicial default, which we run into in some jurisdictions where the courts almost require, if it's a recruiting contract, that it be a judicial default, because we don't have firm evidence of what the candidate was making to base the salary off of and things along those lines.
So that's when the judge reviews it.
The judge has to review it, and the judge will go, okay, it looks like this amount's owed. And that's also usually that's when we can get attorney's fees and things like that on top of a default judgment, is when it's a judicial default.
The downside to a judicial default is it takes much more time. And
Yes.
Sometimes we can get it back in 90 days. Out in California, we have literally had one where they have not answered, and it has been sitting on a judge's desk for about 11 months. Now, we can push the judge to hurry up and sign it, but those, if you push the courts too much, they'll sign it, but it may not be in your favor. Okay, so that's when they fail to answer the lawsuit. The other one is summary judgment, which is where you have an overpowering case. It's very clear that you're owed the funds, and you just basically, the attorney will send in all of the evidence and go, Your Honor, don't waste the court's time running this thing through court. Go ahead and give us a judgment. In my experience, about 10% of the time on a good year, you'll be lucky to get a summary judgment, because the courts view that everybody deserves their day in court. Sometimes you do get it, but kind of give us the logic and the background on that summary judgment.
I mean, a summary judgment, I always, when clients ask about it, my feelings are you aren't going to get it unless you've got a recording of them going, yeah, we owe you every dime.
Exactly.
I mean, you've got to have, you've got to have the murder weapon in the hand. I mean, it's got to be such a level of evidence that there can be absolutely no dispute.
And the only time that I've seen a surge in summary judgments, in my opinion, was during the Great Recession back in 2009 and 2010. The courts got so backed up that I think that they almost started using summary judgments to clear their calendar. That was where I think that you had a much better chance than today. So if you get denied on a summary judgment, and sometimes we'll ask for a summary judgment just to apply additional pressure to the debtor. It's a collection technique, because now they have to hire an attorney, which they already have to hire an attorney, but the attorney actually has to do some work to say, no, you can't give them a default judgment, and here's why, or a summary judgment. And so sometimes we can get them to go ahead and resolve it voluntarily. But if you don't get a summary judgment, it doesn't mean that you have a bad case, and it doesn't mean that you're not going to win and prevail in the end. It just means that the courts have looked at it and says, no, everybody deserves their day in court. Now you have in essence, the judgment after the court. Sam, what do they refer to where it goes through, it's been adjudicated, and you get
that's just a
standard
judgment. Yeah. And
okay.
Also kind of a few gaps to fill in that I feel like are needed is before we get into the trial phase, you're going to get a lot of paperwork from the court or from the attorneys. One, everything's on a timetable, so don't ignore it. Ignoring it is not ignoring the lawsuit. It's really shooting yourself in the foot.
Well, and also if you ignore it long enough, keep in mind, these attorneys are doing it on a contingency basis. They're your attorney. They're also running a business. And if we have a client that's ignoring us, we've had clients where once we've got involved in lawsuits, they just ghost us for personal reasons. They have personal drama. That attorney can resign from the case. And if that were to happen, I'm not always sure that we can find you a different attorney to represent you. So if something is sent over to you, Sam's absolutely correct. Don't ignore it. Also, understand you may have supplied us with every piece of this information, but if the courts or if the debtor's attorney through discovery, which is where they can ask, 1,000 different questions, 100 different ways. If they request that same information, we can't answer those interrogatories for you. The attorney cannot answer those interrogatories for you. You have to go back through the process and answer them and match them to the documentation that we may already have. But that is something that we nor the attorneys can answer for you. So there is some redundancy, and there can be some frustration with clients where they feel like they're having to answer the same questions over and over. It's not that we're being lazy. It's those questions have to come from you as the plaintiff. Samantha, anything else to add on that? And by the way, that was a very good point.
Also, do we want to discuss countersuits?
Countersuits,
rare.
Yes. They are rare. They are rare. About 3% of the time we have a countersuit. I'm actually surprised we don't have countersuits more often, but it's basically you go and you sue your debtor, and you can countersue for anything. Do they win or do they lose? Rarely. I've only had one countersuit that was actually lost that I can think of over the last 20, 30 years. But where they do their damage is the attorney is working on a straight contingency basis. He's not going to charge you a dime to collect it. Now, you have to pay cost if there's, court cost or mediation cost, but he's not going to charge you a dime for his time on that, with one exception. If there is a countersuit, it is handled on an hourly rate because he can spend 10 or 15 hours defending you on a countersuit. And the only way
you can't take attorneys in, I think all states cannot defend on a contingency.
Okay, they have to be able to, so they have to charge by the hour. And there again, the attorneys draw out these rules, which make sure that they generate revenue, but I do agree with you on that. And so if there's a countersuit, you cannot ignore that countersuit. You can hire your own attorney. You can use the attorney that we've sent out there for. If you carry errors and omissions insurance and they say you were incompetent, those are great words because that means in most cases your errors and omissions may kick in.
You cannot defend yourself.
You cannot defend yourself. The attorneys have it to where if you're a corporation or an LLC, you have to have an attorney make those demands. In fact, sometimes we get summary judgments because the debtor will file their own response and the attorneys will get their response stricken because they weren't prepared and presented by an attorney. Is it right? Is it wrong? I'm not here to say one way or the other. I'm just letting you know that's a way to get to the point. So the lawsuit or the countersuit is something that needs to be addressed. And we typically have a pretty good idea. Last year we had 3 countersuits. 2 of them we saw coming a mile away. We said, hey, if you sue them, you're going to get a countersuit. Lo and behold, they did. We occasionally have one a year or so pop up out of nowhere. And it happens because they're never fun, but they're not, as a general rule, and it's not a minimum or a maximum, but it's $2,500 to $5,000 historical average to defend a countersuit. So the process is we send it out to restate. We send it out to an attorney 30 to 45 days after they make a demand. They come back, say, let's file suit. If we've received the counter or if we've received the court costs from the attorney or from the client, we send that to the attorney. The attorney gets suit filed. Anywhere from 30 days to 60 days typically. Sometimes it can run 6 months or longer if they're having trouble serving them. Once they're served, then it's about a 6-month through discovery, and then they set the court date. There are exceptions. New York is insanely slow. Florida can be insanely slow. And so
parts of California.
We tell our clients, figure about a 10 to 12 month process. There's a timeline that we utilize. There are always exceptions to the rule. There'll be 2 or 3 accounts that take well over a year. Samantha, any closing statements or arguments on the life of a lawsuit and what clients need to do before they go that route with us?
I think it's just knowing sometimes as much as you want to rush it, it's at the mercy of the courts, and being patient is sometimes the hardest thing to do, but sometimes it pays off in the end, but it can be a slow and aggravating process.
I agree, but it's a very effective process. 80% of the time that we have suit filed, our clients see money. Now, that's no guarantee that we could get yours collected, but 80% of the times our clients see funds and see significant funds. Last month, we brought in $200,000-$300,000 from our forwarding attorneys. That's the good news. Bad news is we sued most of those 10 to 12 months ago. So it's a very effective way to collect money, but it is a slow process. Sam, thanks for sharing your experience with lawsuits on this with me. Hopefully that gives the clients kind of a better understanding. And those outlines of what a lawsuit is, that's if we handle it, if your own attorney handles it, these are going to be the same frustrations that you have. Sam, I'll let you run. Thanks for joining me, and we'll see you next week.